Hi, my name is Jane Scharf, and the topic I want to talk to you today about is using the Bill of Rights, Canadian Bill of Rights, versus the Charter of Rights and Freedoms to protect you from the use of police with regard to closure to your business or closure to your churches or shutting down your protests. Now, you hear a lot of people talking about the oath that the police have taken to uphold the charter, the Constitution specifically, so your charter rights. Uh, this this is important, except that the charter is flawed. Section 1 of the charter is flawed. It allows the government to override your rights if they believe that there's an important enough reason to do so. This section reads, "The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in its subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society." So the problem is when the police are at your door, their idea is that the government is telling them override your rights, and their position is, well, we have to let the courts decide. So in the meantime, they're going to override your rights, and then later a judge can decide whether they had the right to do it or not for a justifiable reason. Okay, now that's a problem, because if you're trying to run a business and they're using force to close it down, you're done. Your business is not going to survive if you have to be closed throughout the time that you're trying to go to court for it. And the courts are closed and yada, yada, yada. It's very expensive. And it's only maybe after all that. The court could decide, oh, yeah, pandemics are important. Um, so that's not a right that you can take to use in the face of police force. Now, that's not flawed by accident, or it's not just weak because somebody like didn't define the terms well enough. This was done deliberately. This was done by Trudeau Senior, Pierre Elliott Trudeau, in 1982, and it was done in in how do you say in concert with the move to a one world government, because he was committed to that and he was a card carrying communist. So he left that there so that the government can, in the immediate situation, can use force against you arbitrarily because they decide that it's a good enough reason. Now, the whole idea of having rights articulated is to defend you primarily from the government overstepping. So what good is it to have one that lets them think that it's okay to do so, and then a judge has to decide later whether or not they're whatever, that it was reasonable. That's too weak. It's too willy-nilly, and it's thankfully not necessary, because we still have the Canadian Bill of Rights, and it has pretty much the same rights articulated in there, except that it has no Section 1 override. There's no override whatsoever. It says these rights are guaranteed, period. And the only exception would be if the federal parliament, not federal government, not provincial government, not municipal government, federal parliament, which represents all parties actually, so it's a little bit better of an environment. Only if the federal government passes an act that specifically allows the government to override your rights. So today, as we speak, there's no such federal direction or federal action having been created. Therefore, the police have an absolute legal responsibility to respect these rights. Now, in this list of rights, it starts the right of the individual to life, liberty, and security of the person, and enjoyment of property, and the right not to be deprived thereof except by due process of law. So, due process of law, in this case, would only be a federal act of parliament. And then it also articulates the right of the individual to equality before the law and the protection of the law. And then freedom of religion, freedom of speech, freedom of assembly and association, and freedom of the press. So the only chance that the government can override your rights is with this federal act of parliament. And this is what it says in section 2. It says, every law of Canada shall, okay, very strong word, shall, unless it is expressly declared by an act of the Federal Parliament of Canada that it shall operate notwithstanding the Canadian Bill of Rights, be so construed and applied as not to abrogate, abridge, or infringe, or to authorize the abrogation, abridgment, or infringement of any of the rights or freedoms herein recognized and declared. That's pretty clear and pretty firm. So that means if you have an issue with the provincial bylaws, the COVID measure bylaws, there's two. There's Emergency Management Civil Protection Act and the Reopening of Ontario Act. If you have a problem with either one, under either one of those pieces of legislation, they're only allowed to give you a fine. They cannot bring police in because police cannot use a provincial piece of legislation and override your rights. It's a federal act of parliament that's required, and there is no federal act of parliament. So that's pretty, pretty straightforward. You can get a copy of the Canadian Bill of Rights. Just Google Canadian Bill of Rights, and it's right there, section 1, statement of your rights, section 2, they can't override. So the benefit of this is that this protects you in the moment, in the immediate moment. You don't have to go to court after and say, oh, was they allowed to do that? No, if there's no federal act of parliament, they're not allowed to do it, period. So if they do it, it's misconduct because there's no interpretation. It's clear. So that's what I'm recommending for churches and for businesses and for protesters, the same thing. Under the charter, if you're protesting and they come marching in or galloping in or by riding their bike in or whatever way they're coming, and tell you that protest is being shut down under the emergency declarations, not allowed doing that. The Bill of Rights protects you from that activity. They can give you a ticket, and you can go to court after and claim that the ticket violates your charter rights. So that's the idea. So the Bill of Rights stops them from using police, and the Charter stops them from giving unconstitutional tickets. So there's lots of grounds. I won't get into that today, but there's lots of constitutional grounds to fight your ticket once you get a ticket. But in the meantime, you should be able in the meantime, you're legally allowed to stay open until the court determines the issues with the tickets. And in which case you can still stay open. It would just be you have to pay the tickets, and if you lose, and that's the worst that could happen. But if they get away with using police, you're going to be having, your business is going to stop, or your church is going to close down, or your protest is going to stop. So please look it up. Section 1, all of your rights in the Canadian Bill of Rights. Section 2, they can't override it. Now, the reason, it says in there also, some people will say, whoa, wait, it says it's only for federal government. Well, all police are regulated by the federal government, every level, under the criminal code. Now, there is provincial legislation for administration. So you have the Police Services Act in Ontario, but that's for administration. The regulation is federal. And that's the same with courts. Courts are federally regulated and provincially administered. So you have both the structural regulation, and then your rules or your procedures for the administration. So I hope people take this to heart. Get a copy. If you're going to be opening on February 11th or at any other time, make sure that you're armed with the knowledge that the police have no legal authority to close your business. None whatsoever. And if they're like emergency and all that, well, then it's up to the federal government to respond. And they've had lots of time. They've had since March. It's not happening. And there's lots of reasons why that wouldn't pass. That's another whole ball of wax. But right now, that doesn't even matter, because there is no federal act of parliament. And I know a young man that twice confronted police in protest when they were going to ticket him, and he was using this, my right to protest, blah, 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 and the police didn't ticket him. So, yeah, I don't know. I can't guarantee that'll work every time, but if it doesn't, you have an immediate grounds for a charge of misconduct, or any kind of civil action, because there's no gray area. When you go, they've transgressed, and that's the end of it. With the Charter, there's gray. Like, is a pandemic good enough reason to override your rights, or is it not? So it's like, you don't know what court, judge you're going to get. You don't know what considerations there's going to be. It's a maybe you have those rights. That's in the Charter. But with the Bill of Rights, it's not a maybe. You do have those rights, and you currently have those rights. So look it up, and if you have any questions, my email is mjslegalservices@yahoo.com.
6 weeks ago, the House of Commons in Canada passed the Bill of Rights. This was presumably to help to safeguard our rights against an encroaching state and against the encroaching complexities of our society. But rather than prejudge the issue, we have the man who can tell us about that, and I'm going to address my first question directly to him. Mr. Fulton, what was the thinking behind the Bill of Rights? Why was it passed at this last session of Parliament?
Well, there are a number of reasons I could give, but I'll try and give you just two or three of the main ones. The first is one that you have yourself mentioned, and that is the increasing complexity of government and the fact that government now enters into the private life and affairs affecting the private welfare of individuals in ways in which it never used to do, say, 50 years or more ago. So it seemed to us important then to have legislation on our statute books outlining the rights and freedoms of an individual against which a government could not encroach.
Are these new, or is this merely a formalization of what has already existed?
No, we haven't pretended that we're creating a vast number of new rights. We're reducing to legislative and concrete form, thus giving them that much more protection, rights which we have always taken for granted in Canada. That leads me into the second reason, and that is that to to a great extent, if not completely, we in Canada, while possessing and enjoying these rights and freedoms, have possessed them by what I might call the accident of inheritance. No one is prouder than I am of the fact that we do inherit the British constitutional system and the principles of the British common law. But there are many thousands, if not millions, of Canadians now who have come from countries where these principles are not necessarily known, so that for that reason it seemed desirable to have our own declaration of rights in order that they might form part of Canadian legislation rather than merely being enjoyed by the accident of inheritance. And thirdly, it seemed to us that in the kind of world in which we're now living, where there is an ideological battle in process, that it was important that Canada should define what we mean as Canadians by rights and freedoms. At a time when the word freedom itself is being, I think, distorted by communist ideologists and propagandists who claim that they are free, it seemed to us that a nation like Canada might well set an example, if not for the world, at least for ourselves, by defining what we mean by freedom. So that even although our definition of rights and freedoms imposed some administrative inconvenience on government, we should declare to the world that we were prepared to accept that administrative inconvenience because we set at the pinnacle the rights and freedoms which we have now written into our Canadian statute as a Canadian Bill of Rights. That was the sort of reasoning behind our decision and the Prime Minister's decision to introduce a Bill of Rights as a Canadian statute.
Well, Mr. Riddell, you have in the United States a written Constitution and Bill of Rights. Is this would you say these are some of the reasons why you have one too, or is this not applicable?
No, I think it's not applicable at all because ours was written 170 years ago in the face of a war, or in the memory of a war which I won't refer to here with our good friends. But if I may, I'd like to say three things about this new Canadian Bill of Rights. Yes. First, it is very much like our constitutional Bill of Rights in most of the things which it purports to protect against. There are minor things which we have in our Bill of Rights and you don't. There are minor things which you have and we don't. But essentially, though ours is in the Constitution or the Basic Charter, and yours is legislative, which I gather means it may be repealed at any time as ours cannot, their purpose is the same, and their purpose is, of course, laudable. Second, I'd like to say that the Bill of Rights is just as worthless as ours is. It is worthless because it is nothing but words on paper until men put it into action. I've marked a few phrases in it. There is a prohibition against arbitrary detention, imprisonment, exile, etc. Who is to decide what is arbitrary? There is a requirement that someone arrested must be informed promptly of the reason. Who's going to say what is promptly? There is a requirement that you can't deprive a person of a right to a fair hearing, and what does fair mean? In accordance with the principles of fundamental justice, and who is to say what fundamental justice is? Is it the cop on the corner, or is it probably the judges? Our late Chief Justice Hughes once said, "We are under a Constitution, but the Constitution is what the judges say it is." For that reason, I say, essentially, the words of your Bill of Rights, like the words of our Bill of Rights, are worthless without men who will put it into effect in a decent way. But I would say, third, that it's a very hopeful sign. I'm glad you enacted it for this rather practical, I think, reason. When you do get a liberal judge faced with a complaint under either your or our Bill of Rights, he has in these words a lawyer's excuse to act in a liberal way, something which he might not have had if you had not written this in the law. And that, to me, is the real value of both your and our Bills of Rights.
Well,
So
you pointed out some of the shortcomings in your view. Is this perhaps, Mr. McGarry, why the British do not have a written Bill of Rights?
Well, we have a Bill of Rights. We had one in 1689. I think ours is the oldest Bill of Rights. But what really matters, of course, is the individual acts of Parliament that are passed each year by each of the parliaments. Do you have acts of Parliament that have written into them a real protection for the subject? That's what really matters. And general statements in a Bill of Rights are good as pointing the way to the sort of things that ought to be enforced by the law. But what really matters is the individual acts of Parliament, and also, I should have thought, what the courts actually do.
Would you think...
I'd agree with Rodel entirely that this is good as giving an excuse for a judge who wants to do justice in a difficult case. But one must look at the other side of the penny also. All acts of Parliament passed in Canada up to date have now got to be scrutinised in the light of this Bill of Rights. The arguments that can be thought up by any ingenious lawyer as to how some existing act of Parliament conflicts with this Bill of Rights are almost innumerable. And just how much extra litigation this is going to result in, I, as an Englishman, wouldn't like to say, sitting here in Canada.
May I ask
Well, Mr. Fulton wanted to get his oar in here, I think.
There are two things that should be said. I was impressed and, of course, aroused by Professor Rodell's comment on our bill being as worthless as the American Bill of Rights. I would think that the more correct way of stating it is that our bill is as worthy as the American Bill of Rights, and the American Bill of Rights has, I think, indisputably been used and been the foundation of a good many of the heads of the liberty of the subject in the United States. Secondly, I couldn't accept without challenge Mr. McGarry's statement that what is going to happen depends entirely upon the legislation introduced, the subsequent legislation introduced in Parliament, and the extent to which safeguards are written there, because the Canadian Bill of Rights, by express provision, lays down to the courts a rule of interpretation which they will apply in dealing with statutes previously enacted and with statutes subsequently enacted, unless those statutes expressly provide that they shall have effect notwithstanding the Bill of Rights. The effect particularly of this latter provision is that no right can be overridden by Parliament by stealth or by inadvertence. It has to be expressly provided in the statute that the right or liberty sought to be taken away shall be taken away notwithstanding the Bill of Rights. And of course, this Bill of Rights, just as every other statute of our legislation under our system, is subject to the interpretation of the courts. So that given the system of a free and independent judiciary, then the courts are the final protection of the rights and liberties of the subject. That I accept.
May I question, while I admire your optimism, Mr. Fulton? We have had a written Bill of Rights in the Constitution, as you know. I think the strongest and most unqualified statement in our Bill of Rights is in the First Amendment, which says, among other things, that Congress shall make no law abridging freedom of speech or the press. That's a stronger statement even than in yours, though you cover the same subjects. Despite that constitutional guarantee or prohibition, as you will, our Congress has passed laws from almost its very beginning, including particularly the Smith Communist Controlling Act, which was passed some years ago. And those laws clearly abridge the freedom of speech and press. And those laws have been upheld by a majority of our Supreme Court over the valiant dissents of people like Holmes and Brandeis in the old days, Black and Douglas today. I doubt very seriously that your courts, unless they are far more courageous than ours seem to be, are going to overthrow acts of your legislature.